Boston employment law in 2016, continuing his practice in employment law, business litigation, and appeals. In the employment area, he represents both employers and employees before state and federal administrative agencies and courts in cases involving wage payment and overtime claims under the Fair Labor Standards Act and Massachusetts law, sexual harassment, age, race, disability, and sex discrimination, wrongful termination, and trade secrets in non-competition agreements. He also counsels clients regarding day-to-day employment law issues involving COBRA, the Family Medical Leave Act, reasonable accommodation to disabled employees, employment contracts, severance, and employee handbooks. In addition, he has substantial litigation experience in business and corporate law, including shareholder and other corporate disputes, real estate disputes, including partition actions, the Uniform Commercial Code, fraudulent conveyance law, debtor credit matters, and business torts. Howard has done several meetings for us in the past. We truly appreciate him being here today. So with that, I'm going to turn it over to Howard so that he can begin this presentation. And as I said, if you have questions, make sure to throw them in the chat box. We will get to them after. And anybody who cannot leave a question in the chat box because you are calling in, unmute your line when we get to the question and answer. But Elizabeth will go over that again. So without further ado, Howard Brown.
Good morning. Thanks, Chris, and thanks, Ryan. Good morning, everybody. Hope everybody can hear me loud and clear. Before we get started, I wanted to give you a little bit of basically just a little bit of a thumbnail of how we're going to do this presentation, what's in it. Basically, we're going to start out with doing an overview of the Family Medical Leave Law, which I'm going to call PFML, Paid Family Medical Leave. And we're going to go through some of the things which may be familiar to you, but might be helpful to get a refresher on. Basically, the nuts and bolts of the law, what it provides, what it requires. And after we do that section, we're going to talk a bit about the process that's going to be followed when folks actually apply starting January 1st for the benefits. And that's going to be done through those benefits are going to be applied for and administered by this new Department of Family and Medical Leave, which I'll call DFML. We're going to conclude the presentation by talking a bit about just the takeaways. What do you need to do now as a company, if you haven't done already, and things that you might want to think about doing in terms of your employment policies. So that's the way it'll go. And then, of course, we're going to have questions and answers, which I hope somebody in this group will be able to answer. So why don't we just start out with the first slide? So give me 1 second. Why am I seeing? There we go. Thanks. So as the first side, we're going to begin at the beginning, right? Which employers are subject to the Family Medical Leave Law? And the short answer is everybody. And when I say, everybody, I mean virtually anybody. If you've got 1 or more employees, and it's basically the scope of it goes along pretty much with the unemployment laws. So if you have to contribute to unemployment, I mean, there are some small exceptions, I believe, but I'm sure that everybody on this call, you wouldn't be here if you weren't covered. And why is it important, obviously, to talk about this topic? Well, because from my perspective, and I've been doing this 30+ years, this is really amounts to a sea change in the law that governs businesses, and particularly smaller businesses with fewer than 50 employees. So why do I say that? One is, for a long time now, 20 years or more, there's been a federal family medical leave law that applies to companies with 50 or more employees. Now, I'm assuming that many of the folks on this call are going to be smaller than that, because that's typically what I've seen at these events that we do. So if you had less than 50 entitlement to family and medical. So in addition to that, so that's one change. Another is there is no length of service requirements. So compare the federal family medical leave law, where an employee had to work for you for a year and work a minimum number of hours, 1,250 hours. Really, any employee who works for you, newly hired or otherwise, is likely to be covered by this law as long as they meet essentially the qualifications for unemployment, so that if they worked in prior quarters for another company and they've got the unemployment, meet these requirements of 4 prior quarters, et cetera, that are shown in the slide, then they're going to have a right to this. Of course, another big change is that it's paid leave. We've never had that. The federal leave was unpaid. A lot of us are used to the parental leave, which used to, previously called maternity leave, which was 8 weeks of unpaid leave and applied to employers of 6 or more employees. Well, this is, as you'll see, somewhere between 12 and 26 weeks of paid leave, and all employers. So folks who might have had 5 or 4 or 3, this will be new. And last but not least, as of a few years ago, we had the mass earned sick time law that provided for up to 40 hours of sick days. And that itself was new, but it was unpaid. It could be unpaid if you're a small company with 10 or fewer employees. And as I said, this family medical applies to really all companies, and it is paid. So that's the change, and that's the thing that everyone's going to have to get used to. This is the reality, and it's going to take some getting used to. I think it'll roll out. I mean, it's already started in the sense that the contributions are being collected, but the administration of it, the living with the leave, that'll be starting January 1st. So Elizabeth, if we could see the next slide, please. Hello? Thank you. So what are the basics on the paid family medical leave? And I apologize if you already know this, but I think it's worth going through it. Starting January 1st, which is just right around the corner, folks will be able to access most of the reasons for the family medical leave, not quite all, as you'll see. So starting January 1st, employees will be able to get up to 12 weeks of family leave to, quote, bond with a new child, meaning essentially parental leave around the birth or adoption of a child, or for a military, what's called qualifying exigency, which has to do with a family member being called up to active duty. Also, January 1st, employees will be able to get up to 20 weeks of medical leave for the employee's own serious health condition, and up to 26 weeks to care for a family member who's injured in the military service. And then starting July 1st, the last part of it will kick in, which is up to 26 weeks to care for a family member who's got a serious health condition. Now, you say 12, 20, 26, but the maximum number of weeks in a year is 26. So you could envision a situation where someone might be entitled to 2 types of leave in a year. Perhaps for example, someone giving birth might be entitled to medical leave around the birth and then parental leave. But the maximum will be 26 weeks. And it's 26 weeks in what's called a benefit year, not a calendar year. The year starts when the employee uses any leave for a qualifying reason, not when they apply for PFML benefits. And I'll touch on that a couple of times because it's important. It's the period of time starts when someone takes leave, even if they don't apply for these benefits, as long as the leave is for a qualifying reason. Next slide, please. So how much are the weekly benefits? There's a 7-day waiting period. The payments are a maximum of $850 a week, and it's tied to the employee's amount of wage or salary, up to 50% of the state average, and then an additional amount based on the employee's wage, up to a cap of $850. That amount is reduced by certain limited types of benefits, workers' comp, unemployment, or what's called permanent disability insurance, which is not what we mostly think of as disability insurance. Now, the benefits are not reduced by payments under a short-term or long-term disability insurance policy, or if a company had its own paid family medical leave policy. So in a sense, an employee could potentially get additional benefits if you have these things in place, but they can't get more than the employee's wage for obvious reasons. And important to note that you can't receive the PFML benefits while you're using accrued PTO. So there is a 7-day waiting period, as I said, and an employee might say, well, I'd like to use my PTO during that 7-day period. They can do that, but they can't then, while they're collecting benefits, also use PTO after the 7 days. Next slide. So, very quickly, who pays for PFML? It depends on the size of the company. And again, this will be a familiar concept because folks have already been paying into this fund now for quite a period of time. But depends on the size of the company, whether you have 25 or more employees or less than 25. You look at the average during the prior year. If you've got 25 or more, the total contribution is 0.75% of wages, and companies can basically have employees pay about half of that, 0.38, and then the company in that situation, if they've got 25 or more, pays 0.37. If you've got less than 25 employees, and that may be quite a few of the companies on this call, the companies don't have to contribute themselves. They have to deduct the 0.38 from the employees' wages and forward it to the Department of Revenue. Next slide, please. Can we have the next slide? Yes, thank you. Okay, so this might make your head spin a little bit. It does mine. That we now have kind of a number of leave laws out there. So this is the latest one, but as I mentioned earlier, for many years we've had a parental leave law in Massachusetts that provides for maternity or paternity leave unpaid. We've had the Federal Family Medical Leave Act. So it's important to know that this 12 to 26 weeks of leave that we're talking about is concurrent with any leave under those statutes. So you don't say you don't get like 26 weeks here and then another 12 weeks under another law or 8 weeks. As I mentioned earlier, the benefit year for counting the 26 starts the first time the employee uses leave for a qualifying reason, even if they don't file a claim with the department. Potentially the family medical and earned sick time can run concurrently, but only if you're using sick time for a qualified reason, like a serious health condition, as opposed to just going to the doctor's office for a checkup or something, or having a cold. And unlike the federal family medical leave, an employer cannot require the employee to use their paid time off during the PFML. If you're covered by the federal law, you're probably familiar with the idea that you can have a policy that requires the employee to use their PTO first during the family medical leave. Well, you can't do that with the paid family medical leave. If an employee wants to use it, they can, rather than the benefits under the statute, but you can't require that. And then, as it said, they might want to use it during the 7-day waiting period. Next slide, please. One aspect of the law that I think is going, from my experience, may cause some issues for companies is intermittent leave. Okay, what is intermittent leave? Well, it's leave taken in separate periods of time for a single qualifying reason rather than one continuous period. So it's not like, okay, I'm going out for 12 weeks or I'm going out for X weeks, whatever. It's someone may have a medical condition, for example, that requires them to be off for a period of time to have treatment and then come back for a period of time and then go off. Or they may have a regular course of, if they've got a serious health condition, they've got a regular schedule of doctor visits or treatments, and they've got to be out for hours at a time. So, but it depends for the leave. So if someone takes the leave for having a new child, there's no right to intermittent leave. It's only if the company agrees, company and the employee agrees. If it's to care for a family member with a serious health condition or an injured service member or the employee's own serious health condition. It's intermittent if it's medically necessary, and that's something that the employee would have to show. If it's for a qualifying exigency, again, related to active duty service member being called up, then it can be intermittent. And just to go back for a second to say that intermittent, I have over the years had a bunch of questions from companies about this intermittent leave and how it works. It can, I'm sorry to say, be a bit of a headache, but it is what it is. Next slide, please. So what happens to employee benefits and insurance during the family medical leave? Well, this is a little tricky to explain, but it doesn't affect the employee's previously held right to benefits. Meaning if an employee has already earned, let's say PTO, or they had to work a certain number of years in order to get a certain number of weeks, they don't, while they're out on leave, they don't forfeit that. But you don't have to treat the leave as credited services for benefit accrual. So it's not, you know, if you have to, if you accrue PTO on a monthly basis, let's say, you don't have to accrue it during this time period. During the family medical leave, the company has to continue to pay its portion of health insurance, and the employee has to pay their portion of health insurance. And that is something that I think employers will have to stay on top of. Next slide, please. Fitness for duty certifications. The law specifically says that you can have a policy. It's okay to have a policy to require people to get a certification, medical certification, if they're able to resume work. One wrinkle in the statute that I think is important to note is that if you want to get that certification and you want a doctor to be very specific about the fact that the person is cleared to perform the duties of their job, then you have to provide the employee with a job description or description of duties and a notice concerning this within 10 business days of the date that the Department of Family Medical Leave approves the leave. So that's an important thing to keep in mind, because if someone's taking medical leave, you're going to want to know that they're able to perform the job when they come back. Okay, next slide, please. I won't dwell on this too much. The law provides for private plan exemptions where a company can apply, and maybe some of you have and some of you have not, but you can apply to the department to opt out of the law. You're still covered by the law. You still have to allow the leave, but you can basically get the benefits paid by an insurance company if you buy the policy, or self-insure even potentially. But this has to be approved by the department itself. And you potentially could do it for both family and medical leave, or just family or medical. I'm not personally sure. For me and my clients, small and medium companies, I don't see this being very common, but you know, there may be more of it than I know about out there, but you can do it. Some companies have chosen to do it. Next slide, please. So I want to talk a little bit about the process that's going to be followed. From my perspective, this is a bit like an unemployment claim. The model of it, to me, seems very familiar, like an unemployment claim. So what happens? The employee has to file a claim with the department, this newly created Department of Family Medical Leave. It's just a department of the Commonwealth. And they've got to provide all this information, the nature of the leave, the starting date, duration, whether it's continuous or intermittent, et cetera. And they've got to provide backup for the reason. So if it's family leave, what is the family relationship? If it's medical, there's going to be a medical certification. So that's on the employee to do. Now, you as the employer obviously need to know if someone's planning to do this. So the law does require that the employee notify you, logically enough. And they've got to do that at least 30 days before the leave starts, unless it's something beyond the employee's control. You know, for example, a sudden event, a sudden medical condition of the employee or family member. And then it's got to be, quote, as soon as practicable. Now, they have to give you that notice before they apply to the department, and the department won't accept the notice. They won't accept the application unless you've been given notice, and the employee has to demonstrate that, I suppose. And the law does say that when an employee is planning medical treatment, to the extent it can be planned, they've got to consult with the employer and try to schedule it so as not to disrupt the employer's operation. And that is subject to, of course, the approval of the healthcare provider, who's going to have a lot to say about that. Next slide, please. So once the employee responds, an important point I wanted to mention is that the department, which I think has done a terrific job of outreach and publicizing this law, and I want to give them credit for it, you want to make sure that they have a contact person for your company. I know with my little law firm, I'm essentially a one-person company. I got an email asking me who was the contact person. You want to make sure that the department knows who the person is to be in touch with and who will get an email or what have you. Because they will contact the company and they're going to be asking for information. Just as, for example, the unemployment department contacts the company when an application is filed. And they're going to want information about 12 months of employee wages, the job description, whether it's person works full-time or part-time, their schedules, whether they've previously taken leave for a qualifying reason, et cetera, et cetera. And you'll, obviously going to need to respond to that. You'll want to respond to that, and you'll be required to respond to that. So make sure they have the contact. The very last slide in this deck has the website, and it has the phone number for the DFML. And there's also, it also mentions that you can sign up at their website for a newsletter, which I think is terrific and will ensure you get updates.
And Howard, I'd just like to add, we did post in the chat box the link, and we have been joined by the department who will be helping and answering questions when we get to the Q&A period. So I just thought I would interject to add that.
I appreciate that. That's great. Thanks, Chris. So next slide, please. So what happens after the employee applies and the employer provides information is that the department's going to make a decision. They will be deciding whether to approve or deny benefits, and they will notify the employee, and they will also notify you as the employer, and they will notify you of the reason for the leave, whether it's family or medical, et cetera, how long the leave is going to last for, if it's going to be for intermittent leave, the frequency and duration of benefits, and the benefit amount. Now, if circumstances change, the employee's situation changes vis-a-vis health or any of these reasons that someone's on leave, then both the company and the employee are required to notify the department within 7 days. So next slide, please. Now, what happens at the end of the leave? Well, it's job protected leave. And that means that the employee has to be returned to work. So you've got to hold their job while they are out on this leave. And that's a familiar concept, I guess, from, for example, parental leave, the 8 weeks of parental leave that we've had for many years in Massachusetts, that you've got to hold their job and they've got to be restored to their prior position or an equivalent position, same status, pay, and benefits. There is an exception, and the exception, I believe, I meant to check this, but I believe this is pretty much word for word the same exception that's in the parental leave law. So the employee, only reason they don't have to be restored is if other employees with equal length of service or status in the same or equivalent positions have been laid off due to economic conditions or other changes. So in other words, if there has been a cutback at your firm and people who are similarly situated have been laid off, then you don't need to bring the employee back. You're not required. I think they have some preference. And you also, as another point is, if someone was hired for a particular time period, okay, they were not a quote permanent employee, but they were hired for X months or to do a particular project. So then if that time period has lapsed or the project's over, they don't need to be taken back. Next slide, please. So the other thing that is important is that you can't retaliate against someone who takes this leave or applies for leave or brings a legal action for the leave, and you can't interfere with their rights. And this is very important because this is basically the stick. If there's a carrot and a stick, this is the stick. The stick is you really, for example, if you refuse to reinstate somebody, so you're interfering with their rights, so you don't take them back, they can sue you. And unlike a lot of laws, this second bullet will show you that there's a presumption that if a negative or adverse change is made to an employee during leave or within 6 months, if there's a lawsuit, that creates what's called a presumption of retaliation. And then the burden falls to the company to show with clear and convincing evidence, which is a high standard, that it was non-retaliatory. Now that's a lot of perhaps legal mumbo jumbo, but I can sort of summarize for you by saying you don't want to be there. You don't want to be in a lawsuit under this law because of this burden shifting, the presumption and the burden shifting, and because in a lawsuit, if the employee wins, they get triple damages, just as they do for non-payment of wages. And you can be required to pay attorney's fees, which can be substantial. I might add that just as a small plug, what this reminds me is that I tell my clients is it's a good idea to get insurance, employment practices liability insurance, and which potentially, I believe, could cover you for this type of claim. Because as a smaller company, one lawsuit like this can really do you in. So next slide, please. So what do you need to do now? As I mentioned earlier, you want to make sure that the department has contact information. Who do they contact at your company? So if you haven't gotten that email from them and you want to reach out to them, call them, get in touch with them, and I'm sure they'll be happy to get that information. Now you've got to make sure that there's required notices. I didn't talk too much about that, but there was a lot of publicity around that earlier in the year. These notices you had to have given them to your existing workforce already, and you must give them to new hires. There are forms available on the department website. They have them translated into multiple languages, which is great. You're required to post the poster about the law in your workplace. You want to keep in mind at all times this business of 25 or more employees. And I believe this is a point I would ask the department about. I believe there must be a process where annually you're going to, perhaps early in the year, have to report that because it's going to determine whether you contribute or not, or whether it's just the employee. But in any event, you want to sort of be aware of that 25 figure. You, of course, have to continue, as I'm sure you are, withholding contributions for the employee's contribution and your own share if it's applicable to you. Contributions, the state. The last point I'm going to talk about is you might want to consider updating your employment policies and handbooks if you haven't done so already. So let's take a look at that. Next slide. So what kinds of things, if you're thinking about your handbook, what sorts of things should you be thinking about? Well, one is you might want to add a PFML policy. And you, in there, for me, I don't say, I'm not saying, duplicate the statute and write it out. I'm just saying, you want to put in there that there is such a thing, that the company, of course, complies with the law. But then there are some things you might want to add. You might want to make clear that leave under PFML is concurrent with other statutory leaves, like the FMLA or parental leave. That that notice to the company is required. You can put in the point of contact who needs to be notified. You might want to point out that the employees will have to continue to pay their health insurance during the leave and make an arrangement for them to do that. That fitness for duty certifications are required. And as I said, don't forget that you're going to have to provide that some information within a short period of time to the employee after their leave is approved. And you might want to reinforce the fact, which is in the statute, that leave that's taken for a qualifying reason, whether it's family, serious health condition, or employee's health, serious health condition, etc., counts even if the person has not applied for the benefits. You want to look at some of your other policies, particularly those related to leave, okay, such as FMLA, sick time, parental leave, etc. You want to remind folks that those leaves are concurrent if they're for a qualifying reason. And your PTO or vacation time policy. And for example, one thing you might need to do is if you've got an FMLA policy that says that employees are required to exhaust PTO because you had 50 or more employees, you were covered by FMLA, and you had a policy that said you got to use your PTO first. Well, you're going to have to change that because if they're using the paid family and medical leave, you can't require that. So that's something to take a look at. You might want to remind folks that if they use PTO during their leave, that they won't be able to get the benefit payment. And again, that if they use PTO for a qualifying reason, that it counts against the leave entitlement, the number of weeks. So that, I believe, well, let's see the last slide. Basically, if there are questions about it, and I'm sure there will be, we'll try to answer them here. If I can't answer it, maybe some of the other folks on the call can, or the representatives of the department, who of course are more intimately familiar with this. I've put in my contact information. I'm happy to field questions if folks have them. I put in here the website, which is terrific for the department. It has a lot of user-friendly information, as well as the phone number for the department. And my recommendation that there's a menu at their website where you can sign up for their newsletter, which will keep you abreast of any changes. So with that, that pretty much concludes my presentation. I have to say, I'm looking for the chat. Am I supposed to be able to see the chat in this screen?
I will ask the questions for those who were in the chat and have asked questions. But I also want to add before we start that we've been joined by Director Alpine of the Department of Family and Medical Leave. And I will say, as Howard has, they have put together quite a usable site. They are very accessible. We certainly appreciate the director's time today, as well as his staff, because they've had the Herculean task of having to make this work in a relatively short period of time. As you could probably gather from Howard's comments, there are a lot of moving parts here, and as you'll find out as business owners. So appreciate the department joining, and I'm going to throw the first question out there. It was asked a little while ago. Is it 25 full-time employees for an employer to pay their share of the contribution, or is it simply 25 employees?
Yeah, I'm sorry. I think I can answer that. I hope I would, if anybody's got other information other than mine, I believe you're counting all employees. What you're actually counting is the prior year's employment. So it's not like in the middle of the year that, oh my gosh, I had 24 and now I have 25. What do I do? It's the premiums or the contribution rates go according to that figure of 25 based on a prior period of employment. So I imagine for next year, for 2021, it'll be based on what your employment was in 2020. And there's an averaging that takes place where you look, it's not just 1 week, you look at all of your weeks and you count, I believe, and I believe I'm getting this right, that you count all of the employees that you have, no matter, just taking a look at the regulation, include full-time, part-time, and seasonal employees on the payroll. during each pay period. So it's an averaging that goes on. And I hope I've answered that question.
Okay, the next question that I have regarding health insurance, if the employee contribution is a percentage of wages and not a fixed amount, will their contribution then be zero while on leave? And by the way, not all questions will be answered, and if it's something that we cannot answer at this time, we'll make sure to get your information and get the answer that if we can't answer it now.
I'm going to say I don't actually know the answer to that. I'm going to speculate that it's not going to be zero, but that's a speculation. In other words, that it doesn't sound right to me that that would somehow transform. You know, if in the prior to leave the employee was paying a significant portion, I'm imagining they're going to continue to. But that is, I have to say with a caveat, I don't know the answer to that question.
Okay, we will make sure we get that. So if I believe it was Melissa who asked if you could follow up with Elizabeth on that with your email address to make sure we have it, we will get you that answer. The next question, how does PFML apply to married couples?
Well, my belief, I don't know that I can answer that with certainty, but my belief is that each person has a right to their own leave entitlement, unlike some laws where there's a splitting or a sharing, for example, like in the parental leave law. But in any event, does anyone have a better answer than that?
If anybody on the department, from the department, Director Alpine or Johan, if you are on the line to comment.
Chris, can you hear me?
I can absolutely hear you.
Okay, so getting back to the first question about the insurance, I would, consistent with Attorney Brown's response, check the terms of the policy. What does the policy say with respect to somebody that is out on leave that's not contributing wages to that policy? Are they completely out, or are they still covered under the policy? And then the second question I might ask is, are they working a consistent schedule where that percentage is fairly consistent every week to week, pay period to pay period? And, this is really a question as to how the carrier on that side of it would be treating that person while they're out on leave with respect to the health insurance. Just a thought there. What was the last question? Because
the last one was on married couples.
Yeah, I think the question there is related to whether or not two spouses that work for the same company are precluded from getting, both are precluded from getting benefits with us. If that is the question, no. Both, unlike under the FMLA, both spouses can receive up to 12 weeks, for example, of bonding. During the benefit year, they can take it at the same time, or they can take it in succession.
Thank you. The next question is, if you have an employee who has a lot of vacation time and wants to use it, then start up with the PFML, is that allowed?
I mean, I think the answer to that one is that if someone wants to use vacation time for a qualifying reason, they're welcome to do that. And they can if they want to.
The next question I direct at the department. So Director Alpine, if you could answer this one, how will the department contact employers, mail, or do we need to go to the site and check like we do for UI?
We're in the process of developing the whole claims administration system. It's a moving part, as we've heard. We are literally changing process code on an hourly basis. That's how fluid this thing is. It's our objective that the employer will be notified through an online portal, and we'll have the capability of corresponding with the department through that online portal. The employee will log into a portal, fill out their portion of the claim. A notification will then go to the employer, and then the employer has the ability to ultimately get information back to us. In the event that there are issues with respect to computer capability, the call center is available to take that claim online and also correspond with the employer during the course of the claim. And ultimately, we will allow paper filings for those that don't want to use a computer or the phone.
Bill, this is Mary Tipma. Bill, it might be helpful for them to know that the notifications will be done via email, to the extent possible. So people should look for emails if they've been designated as the point of contact as a leave administrator.
And I think it's important for Mary to go on a little further about that, because right now we are undertaking a huge campaign to notify all of our employers. And as Attorney Brown said, he received his. That's great to hear. But we're not getting as strong of a response rate that we had hoped. Mary, you want to get into that a little bit?
Sure, I'd be happy to. Thank you. Yes, I'm glad, Attorney Brown, that your process went smoothly. Happy to hear that. What we have done is taken the point of contact that we had from the Department of Revenue. So those individuals that were listed as the responsible party for providing the contributions, we've reached out to them and asked for their assistance in helping to identify the individual that would be involved in reviewing any claims for leave. So we know that depending on the size of the company, there may be multiple leave administrators, and we've provided a link to a site where you can provide as many names as are appropriate. In order to maintain the integrity of the system, we have provided an individual access code for each employer. And so you're welcome to use that link as many times as you like to provide additional individuals. And what will happen when we go live with the program is that everyone listed as a point of contact will receive a notification that there is a pending claim and that they should go in and review that information. So eventually down the road, we'll be able to get a little bit more sophisticated with that, so that a leave administrator can be assigned for a particular division or department. But at this point, we think it's most important that everyone be notified in the event that there is a claim pending. So we also know that a large percentage of the employers in the state use a payroll processing company or a PEO. And so we have also sent a request to all of these entities so that they can provide contact information. A lot of people want to outsource that, not deal with that. So we're trying to accommodate that by getting the information from those entities as well. So there may be a bit of overlap, and some companies may be receiving a notification saying, hey, you need to provide us with the leave administrator, and the payroll company or PEO may have already provided that information. So we apologize to those who may be receiving multiple outreaches, but we're trying our darndest to get this out to everyone and make sure that that we have the right contacts listed. So as Attorney Brown mentioned, this is a critical step in making sure that your company is set up for success. So we have set the deadline for October 31st. If you need a little extension in time there, I think there's a little flexibility in that deadline, but you also will have the ability to go into your own portal once the system has gone live and make any changes to that. So it's better to have more names than too few. So please feel free to provide as many contacts as are relevant for your organization.
Sorry, can I just to mention, I think that my email may have gone to my spam folder first. And so, it's a tried and true adage to check your spam folder from time to time.
Thank you. The next question, I'm going to group them together, and they're all around maternity leave. When does an employee apply for PFML for maternity leave? The second question in that series is, when does an employee apply for, I'm sorry, that was the first question. An employer had a worker use 3 weeks of vacation time in August for a baby being born. Does this affect them in any way? If they, which I don't think they do, it would, because they've used vacation time, and this, that had nothing to do with the leave. And also, someone has an employee that is due in December and plans to use the leave in January for maternity purposes. When will they apply for that leave?
Well, I can answer some of these, but I would appreciate some of it. Some of this, I think, is a little bit beyond me, and folks from the department would know more. But my understanding is that, in general, that you can apply for the parental leave it can be used within a year of the birth or adoption. So that so for one of the examples that was given, if someone gave birth, I don't know, next month, for example, in November or December, they would be able to use these benefits once the law kicks in on January 1st. When the application would be processed, I would, ask Director Alpine that, or Mary, Jim. I believe there's some. I had heard something about people being able to apply prior to January 1st, at least get the application started.
Yeah. So in the ordinary course, we don't want any claim being submitted to us within 60 days prior to the intended leave. We believe that works well with the 30-day notification requirement that an employee is required to submit to their employer, and I agree that's something that should be added into the personnel policies. Are potentially, it's our hope to have a soft launch in December, whereby we're going to accept just bonding claims. It's going to kind of allow us to test our systems, see how things look from a processing standpoint. So that is intended to go live around the 2nd of December, so stay tuned. And other than that, leave will not begin to run concurrently until January 1st. So any leave used in 2020 for a qualifying reason will not be deducted from their time allotment with us. The reason being is that is not job protected leave under our statute, and therefore we couldn't deduct for leave that was not part of the job protection rights.
The next question I'm seeing here: if an employee worked 2 of the quarters in another state, do they still qualify?
My understanding is it needs to be a Massachusetts employer. The earnings need to be for a Massachusetts employer.
Yeah, those out-of-state wages would not count towards the DFML benefit or financial eligibility test.
Thank you. The next question, just to clarify, under the new program, when an employee calls in sick, is there any change in the current process, or is the employer still responsible for the first 40 hours?
So I assume this question is basically asking, does the Massachusetts Earned Sick Time Law remain in effect? And it does. So that if an employee has, if they have accrued the 40 hours, they can use the 40 hours for an illness. And that would be, whether it was a quote minor illness or a serious health condition, which would trigger the serious health condition would trigger the FML benefits, the PFML benefits, but they wouldn't be paid during the first 7 days. So you can use the 40 hours during the 7-day waiting period.
Thank you. The next question, if you have an employee that is out for an illness now, can they start using the leave in January even though they are out now?
Well, I mean, I would think the answer to that would be it depends on whether they're still ill, suffering from a serious health condition on January 1st, then they would be able to access the benefits then.
Thank you. Can an employee work part-time and receive PFML benefits? I believe that's a yes. Director Alpine shaking his head, so yes, that is correct.
It's just the benefit is, and I guess the question really comes down to, are they normally working full-time, going to a reduced part-time schedule, or are they starting out from a part-time schedule and then going to a reduced schedule for leave? In either case, the benefit is prorated based on the circumstances.
Thank you. I think I have one.
Chris,
oh, Ryan?
Yeah, so there was two questions I just wanted to get a point of clarification on. The first was whether or not you could use vacation time first and then PFML. And then the second was, could you use earned sick time and then PFML? One thing that I do want to clarify is if, in fact, the reason that you're taking that leave is a qualifying purpose for PFML use, that starts the running the clock on the allotment that you have for the year. So if you use vacation time for the first week that you have a surgery that's qualifying for PFML, you've then just lost, that employee has just lost a week of the PFML benefit.
And I certainly agree with that. And one thing I wanted to mention earlier too, just as a point, it seems to me that what that tells you is the need for every company that's covered by this law to keep track of this. And not every company has a human resources department. So you're going to have to figure out a way to track usage. So for example, if somebody does use the sick days for a qualifying reason, or uses, you want to know that, so because that's going to tell you when the 12 week starts or the 26 week starts. So it's, I just think administration is important. Is going to be internal administration is going to be very important for smaller companies that might not be used to doing that.
Thank you. And did you have a second thing, Ryan, that you were going to add, or was that?
No, that was it.
Okay. I think we have one more question, and we still have about 5 minutes left before we're planning to wrap up here. Can it, for leave, can an employee ask, for instance, to have 2 days a week off for the next 6 months? So I believe that's it. Yeah, it looks like an intermittent leave type question.
I mean, I guess the answer is the statute does provide for intermittent leave. And so, like the scenario that I've experienced or seen with clients is, someone who's suffering from a serious chronic, condition, let's say that they have cancer or some other, very serious illness that requires periodic time off, doctor visits, treatments. I mean, they would be able to do that. They'd be able to access that leave intermittently if it's medically necessary. In the example that I gave.
Thank you. If there are any other questions, Elizabeth, I believe they have to hit *6 if they are on the line to ask the question. I know we have a couple people calling in as well who are not on the chat. So if you have a question, hit *6 and you will unmute yourself, and please ask away. If not, do we have any additional questions to add to the chat that have not been answered? Well, it looks like we've exhausted all. Oh, wait, one more. Sorry about that. One more just came in. What happens to the person that is now filling in for the employee on leave for potentially 6 months? So I believe the question is asking about a replacement worker, but it doesn't really get more specific than that.
I mean, the upshot of having job protected leave is that the company, if is going to have to fill that person's position. They're either going to have to distribute their work amongst other people, or they're going to have to hire what amounts to a temporary replacement. Just as you might do, for example, with the existing parental leave, knowing that someone was going to be out for 8 weeks for parental leave. So that is a fact. I mean, that's just a fact.
And it looks like one more question regarding the, will we receive information when the portal is set up for employers' employees? I assume once the portal is set up, there will be additional information available. But I will leave that to Mary and the director.
Yeah, I'm gonna let if Mary's still on, she can take it.
I am.
Go ahead.
Yep. Yes, we will be sending out information just prior to go live or soft launch as well. That gives one more set of steps that an employer needs to go through. And yes, we'll be giving you all that access information and getting you set and ready to roll.
Well, seeing no additional questions, and thank you for that, Mary. I'd like to thank the director for joining us again today and always being accessible to small business owners who have questions. If you have questions, first, I can't thank Howard enough for doing this today and putting this presentation together. We will be making the presentation available to people who are on the call, sending the information along, what was in the slides. Posted several times in the chat box the link to the Department of Family Medical Leave, so you have access to that. I'm sure you already do and have been on the site, but we did want to make it available. So thank you to everybody that was on here today. Thank you to our presenters. Thank you to the department for being here. Any follow-up questions, please feel free to contact either NFIB, the retailers, the department directly. Howard made his information available. Or talk to your local chamber of commerce. We want to make sure business owners know enough about this law because it's coming quickly, and 2 months is going to go by. I'm sure as the department knows, setting everything up, it's going to fly by. So thank you all, and thank you, Elizabeth, for all the background work you've been doing on this and getting this meeting running smoothly. So thanks, everyone, and we hope you have a wonderful day. Take care.